Sure. Tom Nichols, and President Meisner, Tierney, Fisher, and Nichols, a law firm in Milwaukee, Wisconsin. We've been around for, actually, I think we might be the second oldest firm in Wisconsin. We've been around for about 170 years. We were directly involved, and I was directly involved in Wisconsin's adoption of what I refer to as the SALT Parity Bill, and I'll explain why later. Just in general, just kind of on a top of the waves approach, essentially what this does is it takes the 9.85% tax that Minnesota has that it imposes on individuals, which at this point, for the most part, is that tax is non-deductible. What it does is it allows entities to pay that tax at the entity level, and so effectively it becomes deductible. And what's the impact of that? That means right now it's an after-tax percentage tax of 9.85%. If a pass-through entity is eligible for the 199 Cap A deduction, that converts it from a 9.85% after-tax amount to 6.93% after-tax amount. If the pass-through entity is not eligible for the 199 Cap A deduction, it actually converts that 9.85% after-tax to 6.2% after-tax. And this is merely by making the state income tax deductible at the entity level. As you probably appreciate this, and as mentioned by Mr. Wilms, essentially this should not really cause much revenue loss, if any. I would think it would probably be a slight revenue raiser, only because the tax is imposed at 9.85%, which is obviously your top rate. And so as a consequence, it's one of those things that it does have an impact after tax for your businesses, but it shouldn't really have much of a revenue impact on the state of Minnesota. Couple of points in support. One is that you've got what this does, and as I say, I refer to it as a SALT parity bill because C corporations got pretty beneficial treatment out of the Tax Cuts and Jobs Act. The tax rate was reduced from 35% all the way down to 21%. That's a pretty big reduction. In addition to that, C corporations are entitled to fully deduct all of their state and local income taxes. For pass-through entities, that wasn't the case. For pass-through entities, the top rate went from, depending on how you calculate it, maybe 39.6% down to 37%. And then with the 199 Cap A deduction down to maybe 29.6%, but in any event, not anywhere close to the 21%. And and state income taxes were fully effectively with the $10,000 cap for most closely held business owners were effectively non-deductible. So whereas you had rough parity between C corporations and S corporations, and C corporations on the one hand and S corporations and partnerships on the other, before the Tax Cuts and Jobs Act, you now had a pretty dramatic difference. And I just want to say that one of the reasons why it is important to have parity between pass-through entities and C corporations is especially for closely held businesses. A single tax system works much, much better. A double tax system where essentially business owners have money sitting in their corporation, which is one of their pockets, and money sitting, at home and elsewhere in another one of their pockets. And whether they move it from one pocket to another pocket, or they pull it out to invest in another business or whatever it is, for closely held business owners, I've represented closely held business owners now, by about 40 years. And it is highly disruptive. And it was only with the Tax Reform Act of 1986 that the large majority of closely held business owners essentially switched to a single tax system, which is the pass-through either S corporations or partnerships. And it had a huge impact on their behavior. Up until that time, there were people like me making a lot of money by essentially advising businesses how to avoid that second tax of under the C corporation double tax system. It was disruptive, and literally closely held business moved almost in total, I mean, a large majority of closely held businesses moved to pass-through taxation, which it literally caused them to call me less, and to have less have tax drive their decision making a lot less, and it was a lot less intrusive and disruptive. But it might not have been good for tax lawyers and accountants, but it was wonderful for closely held businesses, and I can come up with numerous examples from my own practice, and I'm sure there are others. The only other thing that I would mention to you in connection with this, and that is, you're obviously in a competitive environment as a state. You've got Wisconsin next door. Our top rate is 7.65%. With this, and we passed Wisconsin Act 368, which essentially allowed entities to elect. So effectively, our rate, depending on whether you're applying the 199 cap A deduction, 20% deduction for pass-through businesses or not, effectively, our pass-through business rate is 5.56% if you qualify for the deduction, or 4.98% if you don't qualify for the deduction. So that the comparison there is between 9.85% in Minnesota and somewhere around 5 to 5.5% in Wisconsin. Obviously, from a competitive advantage standpoint, I like Wisconsin, but I like Minnesota too, just from the standpoint of not having taxes drive decision making. It would make sense for Minnesota to be more in line, for example, with Wisconsin. As far as I'm not really being asked to comment on the deduction issue, I'll just say two things. Clearly, by definition, as you can see from the language in the statute, what you're talking about, even though there is a significant revenue estimate, what you're talking about doing in Minnesota is clearly consistent with congressional intent. Not only is it consistent, Congress actually passed a bill to make sure that it was implemented by the Treasury consistent with their intent. So the other thing that I would emphasize too, and this is just true in every state, and that is when you have a disparity between the federal treatment and the state treatment, that always causes a malpractice for accountants and lawyers, but it also just creates complexity. And this one wouldn't be any different in the sense that people would have to track either the income or the deductions. And that's a whole set of calculations, especially if it would be done at the deduction level. It would be a whole set of calculations that wouldn't take place for federal income tax purposes, but would take place for state income tax purposes. So that just a lot of additional compliance in order to accommodate the differing federal and Wisconsin rules. So thank you very much, Madam Chair. I appreciate the opportunity to talk, and I will sit back and wait for questions, if any.
Thank you, Mr. Nichols.